So, good morning, everybody. My name is Laura Spueina, and I work in the analyst team, mainly following media topics.
So, hello, everybody. I'm Michelle, and I'm, like Laura, working on media, except I've been working for more than 20 years for Cullen International. So, good morning, everybody.
And welcome to this Cullen International webinar. Before starting, allow me a couple of words on Callan for those who don't know us. So at Callan International, we provide a regulatory intelligence service covering 4 communication sectors, so telecoms, media, digital economy, and postal. And we also provide an horizontal competition law service, which covers the 4 sectors that I just mentioned. In terms of geography, of course, we cover Europe, but we also cover the Americas and the Middle East. And what we do in practice is mainly to analyze regulatory developments and to benchmark the regulation in the different countries. And we do it in a neutral and independent way. Also, a couple of practical things about this webinar. So, of course, you can watch us on the video, but you can also follow the slides at the center of your screen. You can also ask us questions, and we'll see the questions popping up in real time. So we might address your questions as we go through the presentation, or we might do it at the end. It depends on the questions. And then in case we don't have time to cover them all today during the webinar, we'll follow up with you after the webinar in the next couple of days, let's say. Also, at the end of the webinar, you'll be able to download slides and some material that we have selected for you. And also, we will be very pleased if you could take a few seconds at the end of the webinar to evaluate our presentation and you know, the quality of the webinar also. So I think we are ready to go and to talk about the content. So the topic of this presentation is the regulation of online platforms at the EU level. In particular, we are going to cover the recent measures that were adopted or proposed, which impose new responsibility over content sharing platforms for the harmful or illegal content that is uploaded by their users. Now, what you should know is that on online platforms, the European Commission took a problem-driven approach, meaning that instead of proposing a new framework covering all online platforms or revising their safe harbor statutes that was adopted back in 2000, it chose to propose several targeted measures whereby each measure addresses a specific problem that is raised by a specific type of platform. Now, I'm not going to mention all of them today, but you should know that all the problems identified belong to one of 3 main areas. The first one is the lack of a level playing field between traditional players and certain online platforms that provide comparable services, such as, for instance, between telecom operators and OTT communication services. The second is the lack of transparency and fairness of online marketplaces toward their consumers and also business users. And the third one is the proliferation of harmful or illegal uploads on content sharing platforms or social media. Now, in this presentation, we'll only cover EU initiatives that address the third area, and in particular, the new rules for video sharing platforms that were included in the revised Audiovisual Media Services Directive that was adopted in December 2018. We'll cover the value gap, so-called value gap provisions on the new directive on copyright in the digital single market that entered into force just last week. And we'll also cover the draft regulation on preventing the dissemination of terrorist content online that was proposed by the Commission back in September 2011 and is still under discussion. Now, the plan is not just to explain to you these three sets of provisions separately, but what we'll try to do is to put them in comparison, also to highlight the downside of this Commission-targeted approach in terms of complexity and fragmentation. And then after we have compared the three sets of rules, we'll also present to you the European Commission initiatives that are self-regulatory initiatives on hate speech and fake news, and also a couple of interesting developments at the national level.
Yes, so thank you, Laura. So you can imagine it's going to be quite an intense webinar. So we'll start perhaps with the current liability regime, because in fact the three initiatives that Laura has briefly presented to you do create a considerable amount of tension with the current liability regime. So just to go back in time a bit, the Electronic Commerce Directive is where the liability is actually enshrined at the moment in EU legislation. And the Commerce Directive is an old piece of legislation because it dates back to 2000. So at a time when there was no Googles, no Facebooks, no YouTubes. And basically it enshrines the principle, the very important principle, that passive intermediaries, so we're talking about here the telecom operators, but also the ISPs, and also the hosting service providers, and I'll get back to that in a minute, incur no liability for third-party illegal content that could be transmitted on the networks or that will be present on the platform. So that's the basic principle. Now, there are four other elements that I think are important to highlight. The first one is the liability status of what we call hosting service providers. Now, you might think that's quite an outdated word for things that for Google or Facebook, but in fact, it's still under that regime that these big operators are covered. And so these hosting service providers are not liable, as we've just mentioned, unless they actually have knowledge of the fact that there's illegal content or information on their platforms. The other big element is if they've been informed, so if they do get that knowledge, then they have to rapidly take down the illegal information. And that's called the notice and takedown regime. Now, the third big element is Article 15, and I'm mentioning the name of the number of that article because we're going to be getting back to that during the webinar, is the idea that these intermediaries, so ISPs, telecom operators, hosting service providers, can never be asked to monitor in a general manner the information or the content that's contained on their networks or on the platform. So that's Article 15. But of course, in fact, they do need, all these intermediaries do need to collaborate with law enforcement. Once a court orders them to do something, then of course they have to. So that's the basic framework. And so 2000, not being reviewed yet, but maybe with what we're going to explain in a minute, maybe this is an area where there is going to be a revision of these basic rules. So let's go to the next slide. So as Laura mentioned, we're in an area here where, in fact, the European Commission decided to amend or adopt new proposals really to target specific areas where there was specific concerns. So the first area is the introduction of this new copyright directive and this new Article 17. Now, of course, now you probably don't know what Article 17 is, but if I say Article 13, I think maybe people will remember the controversy that surrounded the adoption of this article, but it's now become Article 17. And it was there to address a very specific concern, which was the so-called value gap that Laura mentioned. And this is the idea that on YouTube, on Facebook, etc., we watch a lot of films, we listen to a lot of music, and in fact there was the fear that the right holders weren't getting their fair share, weren't getting enough royalties for everything that we were actually watching for free on these websites. whereas the platforms, in fact, were making quite a lot of money because everybody was watching this content. So this is the so-called value gap. So the idea here now in the new directive, and I'm going to get back to it in more detail during the presentation, is that we're making the platforms responsible for seeking the agreements with the copyright owners and to therefore pay them the royalties. Now, the second big directive that was amended is the Audiovisual Media Services Directive. And we're going to talk about one specific set of rules which concern the video sharing platforms. And the idea here was, in fact, that on television or on a video on demand service like on Netflix, all these providers, televisions, have to respect a lot of content-related rules, protection of minors, all sorts of things, to protect us viewers. Whereas when we were watching all these videos on the user-generated platform, there was no form of protection. So the idea here was to introduce some basic levels of protection for minors on the one hand, and for the general public that should not be exposed to violence or hate speech. And in the course of adoption of the directive, another set of rules were introduced, which are a little bit of a different nature, I would say, which is to do with respecting basic rules on advertising. So the platforms have to also comply for their own advertising with the same qualitative rules that have to be complied with by televisions or on-demand service providers. So, for instance, rules to make sure that we know that what we're watching is actually advertising, or the fact that we shouldn't be exposed to advertising of medicinal products, for instance. And then the third proposal that we're going to talk about, as Laura mentioned, it's not yet adopted, but obviously this terrorist content proposal is there to protect us against being exposed to terrorist content, and to make sure that if there is terrorist content on the platforms, it's taken down very quickly. So that in a nutshell is the basic objectives of the three initiatives that we're going to be talking about in more detail.
So if we start a comparison, the very first thing that emerges is the different the different scope of application of these three sets of rules. So they all cover those commercial platforms that enable users to upload and share content, but each one of them focuses on different types of content. So if we take the new rules in the AVMS directive, they cover platforms where users can mainly upload audiovisual content, meaning films, audiovisual programs, user-generated videos, including if live streaming. Now, Article 17 of the Copyright Directive covers those platforms where users upload a large amount of copyrighted works, irrespective of the type of works. So it covers the video sharing platform that are in the scope of AVMS rules that I just mentioned, but it also covers platforms where users can share music or photos or literary works, provided that copyrighted files are a large amount. And then the terrorist content proposal covers platforms where users share any type of information and material, including, for instance, websites where users can post comments, such as, for instance, online newspapers. Now, another main difference between the three sets of rules lies in the level of curation by the platforms with the uploaded content. Because if you take the copyright and the AVMS rules, they only cover platforms that on the top of storing the content that is uploaded by their users, they also organize it or manage it, if you want. Well, if we take the terrorist content proposals, it also covers those hosting service providers that only play a passive role. So those that only really store the information uploaded by the users, and irrespective of whether this information is made public. So, for instance, this proposal would cover also cloud services or file sharing services, like, for instance, Dropbox, where users privately share between themselves files with basically zero involvement by the service provider.
Yes, so Laura, we've got a question here about, in practice, does this mean that Facebook, say, would be covered by all of these initiatives, or can we draw distinctions there? What information do we have?
Well, it's a difficult question. Well, it is very easy for the terrorist content proposal, where you can imagine that the scope is very broad.
Yeah, that's easy, yeah.
Yes. So basically, it covers any type of social media, including Facebook. It covers any type of content sharing platform like YouTube and others. It covers, I mentioned the websites where users can upload comments. And also, as I say, the hosting service providers like cloud services or file sharing services. Now, the difficult bit is the copyright and AVMS rules. Because, well, if I can mention the easy example, which is YouTube, that easily fits within both definitions. So that is for sure covered by both set of rules. Now, if we take Facebook, that is more difficult because in principle, social media are covered by both the directive. But then in practice, it will be up to the competent authorities at the national level to assess on a case-by-case basis whether a specific social media is included in the definition. So to give you an example, if we take AVMS rules, it will be up to the regulatory authorities, the audiovisual regulator of the country that has the jurisdiction over Facebook, which is Ireland, to assess whether Facebook provides user-generated video or audiovisual programs to inform, entertain, or educate the general public as an essential functionality. So if that is an essential functionality of the service, but the regulators will have some help from the European Commission because the Commission is going to issue a set of indicators to allow this case-by-case assessment, and the indicators are not available yet. That will be done by the end of the year.
And then, of course, the other question is, what if there's no establishment well, what about non-EU providers? Will they be caught?
Well, that is, again, different for each initiative because they cover some or many non-EU platforms depending on the case. And the discriminatory factor there is the level of connection with the EU that is required to be in scope. So I'll give you an example. If you take AVMS, for a non-EU platform to be covered, the platform needs to have a connection with the company established in the EU at the level of the ownership or the legal structure of the company. If you take the terrorist content proposal, you only need the provider, the service, to have a connection with EU consumers. So, for instance, if the service targets EU consumers, then it is included.
So, no company located in the EU. Yeah.
Or, for instance, if the EU consumers are a relevant number, a significant number, then the service is included. If you take the copyright rules, there you don't actually need a connection with the EU. It is sufficient that the service is accessible from the EU to be covered by Article 17, because the copyright infringement would take place in the EU. Is it clear?
Well, yes, for me it is. I hope it's clear for everybody. Let's maybe move on to the next point that we've decided to compare, is the ability of the member states, despite the fact that we have we'll be having all these EU rules, to adopt stricter or more detailed rules. And here again, we see a very split situation depending on the proposal we're we're looking at, the initiative we're looking at. The most easy situation is probably going to be in the terrorist content proposal, just because of the choice of the legal instrument. It's in fact a regulation, which means that the member states don't actually need to adopt implementing legislation, and the regulation is supposed to be completely self-standing, and all the rules are supposed to be contained in that piece of regulation. Now, the other situations are a little bit more, well, they're completely different, in fact, because in the Audiovisual Media Services Directive, it's very clear that member states are allowed to adopt more detailed, more strict rules as well than those that are foreseen in the directive. And that, in fact, wasn't at all anticipated at the start. When the European Commission proposed the adoption of this directive, it really wanted to put an end to the ability for member states to adopt more far-reaching rules. But in fact, during the course of adoption, things went a bit wrong for the European Commission, and we've now ended up with a minimum harmonisation approach, so giving member states quite a lot of freedom to adopt in their legislation further rules. Of course, they can't do everything they want. They will have to comply with these Article 15 and Article 14 and 15, sorry, of the e-commerce directive that I mentioned at the beginning of the presentation. For the copyright directive, in fact, it's simply a directive, which means that member states are allowed to adopt a more detailed rule than the ones that are foreseen in the article, but we don't expect any major differences on the substance of Article 17, at least. So now I think we can move on to, yeah, maybe what's the core of the responsibilities of platforms in each of these three areas. And so now we're deep diving into actually what they have to do, but obviously we can't go into a full-fledged explanation because it's a lot of information. So on the copyright directive, what basically platforms need to do is you have to go back to the idea that, in fact, it's them that are responsible now for clearing the copyright and for negotiating agreements with the right holders, even for the user-generated content. So if you, Laura, if you upload something that's protected by copyright, well, it's still the platform, not you, that will have to clear the copyright. So basically, the idea is that platforms have to make their best efforts to obtain these authorizations and copyright clearance. But if they can't, despite all their efforts, obtain copyright clearance, then in principle they're not liable. But then the story doesn't really stop there, because right holders are also given the right to identify in advance to the platform a number of works that they don't want to be included on the platform. And you as a platform, you have to prevent the availability of these works on the platform. So let's use the bad word. They have to filter the content at that stage. And then, of course, the rule remains that if they receive a notice from a right holder of copyrighted work that's available on the platform, and it shouldn't be, then they have to take down that particular song or video, and also prevent the future upload. So that goes a bit further than the e-commerce directive. So again, a filtering idea. In the audio, so the platforms for copyright purposes have the shift of responsibility has really changed. Insofar as the Audiovisual Media Services Directive is concerned, it's a little bit less direct, their responsibility in a way. They've got to take so-called appropriate measures to protect minors on the one hand against harmful content, and the general public against hate speech and incitement to violence and hatred. So basically they have to adapt their terms and conditions and tell us that we're not supposed to upload this type of content. and apply the terms and conditions, and maybe we'll get back to that in a minute, then they have to operate rating systems and age verification systems to make sure that we're allowed to watch what we want to watch. They have to put in place parental control systems, operate reporting and flagging systems for people to report content that shouldn't be on the platform, and of course also comply with the rules on advertising, but I'm not really going to get into that into too much detail here. In relation to the terrorist content proposal, here for the first time we see the introduction of an idea that the platforms will have a duty of care to make sure that we are not exposed to terrorist content. And here, on top of that, there is an obligation for the platforms to actually take down terrorist content within 1 hour after receiving a removal order from a competent national authority. And then if platforms have already been exposed to terrorist content, then they've got to take so-called proactive measures to prevent the re-upload of terrorist content and to remove new terrorist content that would arise on the platform. And then there's the traditional things about adapting your terms and conditions and applying them and publishing annual transparency reports to public authorities. So there we are.
But Michelle, I think now I have a question for you, because I think you already implied it by explaining the rules. But in practice, so you're saying that each set of rules have a different impact on the liability regime of the e-commerce directive. Is that what you're saying? Yes, so
I'll just maybe repeat a little bit the general idea, because it's really complex here. So it's the idea that, first of all, for all pieces of legislation, there is wording on the relationship between the legislation and the e-commerce directive. Now, for the copyright directive, the situation is the most clear-cut in a way, and we have a complete carve-out of Article 14 in relation to copyright. So it's really the idea now that it's the responsibility of the platform, and in fact, all the rules that I've explained in Article 17 supersede the rules of the e-commerce directive in Article 14. So you can forget about it, about the fact that they're not liable. They are liable for copyright infringements, even when it comes from third parties, if you want. The Audiovisual Media Services Directive is probably the most close to the rules of the e-commerce directive, and probably doesn't depart from them so much, especially that the directive itself says that all these appropriate measures cannot amount to an ex-ante control or an upload filter. But of course, we'll have to see in practice at member state level once they've implemented these rules, because as I said before, they can go further, to what extent they will remain compatible with Article 14 and 15 of the e-commerce directive. And one of the elements that maybe could be problematic is where I talked about adapting your terms and conditions. Well, also you have to apply them. So what does that mean? You know, how far does the platform need to go? And then on the terrorist content proposal, I think there's two things to be particularly wary of in a way, is the introduction of this new duty of care, which actually hasn't really been defined in the directive. But what will that in fact imply? If it's just complying with removal orders of public authorities, you know, to take down terrorist content within 1 hour, that seems to me to be completely compatible with the e-commerce directive. But then if it's, when we're talking about the proactive measures for exposed platforms to make sure that content that isn't re-uploaded or that other terrorist content isn't present on the platform, there we could wonder if it's not going a bit further than the e-commerce directive.
Yeah. Also because on the top of what you said of the impact on the terrorist content measures, you need to take into account that the application of these rules is not proportionate to the platform size. Mm-hmm. While if you take the copyright and the AVMS rules, the application of measures must take into account if the platform is a new entrant to the market, is an emerging platform. And it's particularly interesting what's in the copyright rules on this, because the directive requires platforms of any size to seek the authorization of right holders, as you said. But if a platform is both young and small, it is going to be exempted from the filtering that you mentioned. And if on the top of that, it also has a small audience, it will be exempted from both the filtering and from making sure that content that was already taken down is not uploaded again in the future. And then something else that is interesting, I think, to highlight is that in all the three initiatives, we find some provisions that at least seek to safeguard the interest of users and their freedom of expression. Because all platforms will have to set up and operate a procedure to enable users to complain if they think that the removal of their uploads was unjustified. And even when the platform is complying with an order that comes from an authority about taking down terrorist content, they will still have to inform the uploader that they have removed the content. And upon request, they also need to explain the reasons for that. Then, of course, you can say that a user can always bring the case before a court, but that is a bit unlikely to happen. So for copyright and AVMS, both directive also requires member states to make available in the countries an alternative out-of-court mechanism to settle the disputes. And then on the top of that, for copyright uploads, you have additional safeguards that say, for instance, to make sure that the platforms don't take down memes. And there was a big debate about memes when the directive was adopted. Or for instance, to make sure that they don't automatically filter the content without a human review, which I think it's interesting to mention.
So yes, so the other topic we decided to look at across the three initiatives is about enforcement, precisely. So here we've got a split situation. You'll not be surprised to hear. In the terrorist content proposal, we probably got the most comprehensive system that's foreseen. And we have sanctions that are foreseen in the proposal. So fines of up to 4% of the annual global turnover of the platforms if they systematically breach the removal orders. So that's big fining, basically. And then the proposal also foresees that non-EU services that are targeting the EU need to appoint a representative in the EU to be responsible for all the removal orders, etc. And then there's a cooperation procedure that's provided in the directive between the various national authorities that could be sending removal orders to platforms. So all this is quite elegantly addressed in the proposal as it stands. Now, in the two other pieces of legislation, in fact, enforcement is really not foreseen very much, which is probably a bit problematic. And basically, the sanctions are provided nowhere. So that's really a question for member states to decide what if platforms don't comply. And then the only other thing that we do have in the Audiovisual Media Services Directive, we know that it's going to be the regulator of the member state of establishment of the platform that will assess whether the measures taken by the platforms are appropriate or not. And of course, we know that our friends from Ireland are probably going to have a lot of work because a lot of platforms are in fact established there in Ireland. So, but that's basically all that we really have on enforcement. Whoops, I've gone the wrong way. So in fact, this part of the webinar is finished. So this was about the regulatory initiatives that we have, and now we're moving on to the self-regulatory approach that the European Commission has also decided to adopt for 2 areas, and that's in the area of fake news or online disinformation, as we call it here in Europe, and in the area of online hate speech. Now here, the European Commission fostered basically this self-regulatory approach. It said, companies, you decide, you try and sort out the problem. And for fake news, a code of practice was adopted in 2018 in September, and it was signed by some of the big platforms, Facebook, Google, Twitter, Mozilla, and the advertising trading associations. And where we stand at the moment is that the European Commission is taking a very close look at this self-regulatory approach and the functioning of the code of practice, and will undertake a comprehensive assessment of the code of practice by the end of this year, and possibly will adopt legislation next year. So the code of practice is also being monitored by ERGA, which is the European Regulators Group, audiovisual regulators group, and so the media regulators, in a way, have a role to play in monitoring the code of practice. So, what are the commitments of the parties that have signed? It's basically that they should disclose publicly if there is political or issue-based advertising on their platforms. They should try to disrupt the advertising and money flows that go to providers of online disinformation. They've got to make sure that automated bots that are used very, very widely are countered as much as possible. And there's also a strand on sort of media literacy type ideas to help users to try to understand what's authentic and authoritative information compared to fake news. And then there's the idea that they have to empower fact-checking organizations and research in the area. So that's for fake news. For online hate speech, again, we have a self-regulatory approach, which is older. It was adopted, the code of practice was adopted in 2016. Fostered very much by the European Commission, signed by Facebook, Microsoft, Twitter, and YouTube. And since then, a few additional platforms have signed up, including some European ones, like Dailymotion, jeuxvideo.com. And here, the European Commission has given out very positive signals and has said that the system seems to be working very well. And the Commission is satisfied. And this is a press release of February 2019. Now, the main commitments of the operators is to have in place mechanisms to receive and review notifications regarding illegal and hate speech, and then to review the notifications within 24 hours and take down the hate speech. So thing to remember is for fake news, we have a self-regulatory approach that's very much scrutinized by the Commission, and we don't know if it's going to work or not. But for hate speech, probably the Commission sounds as if it's happy. So maybe we go to some national developments, because I think it's really important to see that despite the fact that we've got European legislation and self-regulation, it's not stopping the member states from moving on as well in this area. And this, of course, we'll talk about it, it may be a bit problematic. So the most one of the most interesting developments I see is the fact that the UK government, has adopted a white paper on online harms in April. And this white paper might not seem anything, but in fact, it will materialize into the adoption of binding legislation, probably towards the end of the year. And their idea here is to adopt a comprehensive regulatory framework addressing all sorts of online harms. So illegal and harmful content, everything that we've talked about, well, not copyright, because that will be covered in a separate piece of legislation, but basically terrorist content, protection of minors, hate speech, cyberbullying, all sorts of things that we don't even have covered at EU level. And also introducing here a new statutory duty of care, so this is a bit like in the terrorist proposal, upon a broad range of operators, big and small, and websites, and not only platforms. So, you know, everybody could potentially be covered. All this would be overseen by a single independent regulator, which could either be an established regulator like Ofcom or a newly created regulator. So a really a big move there in the UK. You've probably all heard about the network enforcement law, the German initiative that was adopted, legislative initiative that was adopted in 2017. And this covers social networks and VSPs, but only the big ones, the ones that have got more than 2 million users in Germany. And again, there's the idea that they do need to appoint a legal representative in Germany. They need to install a complaint mechanism, and they need to remove obviously illegal content within 24 hours. For other types of content, they have a longer period of seven days. And then they need to publish transparency reports every 6 months, and big fines can be imposed on platforms that don't respect the rules. So maybe, yeah, if you go back.
Yes, I think we are coming to an end, I mean, to our conclusions. But before, I'd just like to highlight a couple of dates regarding the next steps. So after the summer break, Parliament and the Council are expected to start negotiations on the terrorist content proposal, in principle on the basis of the positions that they have already adopted. Then, as Michel said, by the end of the year, the Commission is going to undertake a comprehensive assessment of the fake news code, and eventually the new Commission could come up with legislative measures if it assessed that the self-regulatory approach was not satisfactory. By the end of the year, the Commission will also publish, or at least is expected to publish, its guidelines on the definition of video sharing platforms in the new AVMS rules. And so we'll present the set of indicators. And then member states will need to transpose AVMS rules in their national legislations by the 19th of September 2020, while they will have until 7 June 2021 to transpose the copyright rules at the national level. And in the meantime, the European Commission is going to organize meetings with stakeholders and will issue guidelines to basically on the practice implementation of Article 17. You probably know already that in the meantime, Poland has challenged the directive before the European Court of Justice, in particular Article 17. So this could delay the process. And so I think we can talk about conclusions and wrap up our presentations. So regarding where we stand, I do think that the analysis that we gave to you during this presentation clearly showed that the problem-driven approach is leading to a fairly uncoordinated result. We have seen 3 legislative instruments at the EU level, all with a different scope of applications that are imposing different measures, which have a different impact on the existing safe harbor provisions, as Michel very well explained. We expect regulators at the national level and authorities to face some challenges in enforcing the AVMS rules on video sharing platforms, but also the copyright rules. And also because of the national legislative initiatives that Michel just mentioned, in the areas that at the EU level are covered by self-regulation, well, we expect to see some tensions between the different member states when these rules will be implemented.
I was looking at the questions. So where next? So here we're sort of wondering what's going to happen next with this legislative framework. Well, of course, one of the areas that could be addressed and where there is probably a need to at least discuss it is the review of the e-commerce directive. So we've spoken about Article 14 and 15. The initiatives that we've mentioned do create some sort of tension with these rules. So that obviously the question is, should we review the e-commerce directive? And of course, what's funny is when you see that, in fact, they're regulating in the e-commerce directive so-called, how do you call it? I've lost my word now, so-called passive platforms. But the question is, of course, that these platforms, in fact, are becoming more and more active, and we're asking them to become more and more active. So is it sustainable to have a legal regime considering that they should be considered as passive providers? And then, of course, the UK initiative shows that there is probably scope for streamlining this legislation into a single legislative framework. And, you know, it seems to be, it doesn't seem to make much sense to have these initiatives dotted about into different legal frameworks with different mechanisms, different conditions under which non-EU suppliers would be caught, different sanctions. I mean, everything that we've gone through. So, would it make sense to go to a single piece of legislation governing all these questions? And then the other topic, of course, that we could mention as well is the role for co-regulation, because we've mentioned during this presentation regulatory developments, but also self-regulatory developments. And then there's something that stands a little bit in the middle, which is co-regulation. And this is the idea that you let industry decide, but you have a very strong oversight from the regulators. So that's co-regulation, and co-regulation is in fact very much foreseen in the implementation of the Audiovisual Media Services Directive, and especially on the provisions on video sharing platforms. So, but it's not actually mentioned in the other pieces of legislation. So, but I think there probably is at least a role to play for co-regulation, especially given the fact that there is so much content to be supervised in a way in so many areas that maybe leaving it completely only to a regulatory authorities is not really going to work. So probably there is probably scope for co-regulation. Then, of course, making sure that these rules are enforced in practice, and that will fall upon some, especially in the audiovisual media services area, on the roles of regulators. And here it's making sure that the regulators actually have the means to do it, the powers to do it, the competence to do it, and bearing in mind that some regulators will have it harder than others because some of the platforms are established in some countries, whereas some of the platforms, you know, some other countries don't have any platforms to regulate. So, yes, so those are the where next conclusions that we wanted to bring to your attention. So, Laura, do we have any questions that we want to talk about? We've got one here. We talked about terrorist content. Please, the definition of what terrorist content is. Well, yes, basically, I had it down because I'm not very good at remembering definitions. It's to do with making, I can't remember now, it's something to do with making available, it's defined in in the directive, in the regulation, but in fact, in the course of adoption of the regulation, people want to refer back to an EU directive on terrorist content. But it's basically making available any content that could incite the commission of a terrorist offence, or if you're part of a terrorist group. But it's a pretty wide definition, but we can get back to you on the precise wording of the definition.
Yes, because all questions are very detailed. I mean, they address very detailed rules. I'm not sure everybody is interested in those.
But basically, I think what we'll commit to do is to answer every single one of these questions, maybe not today or tomorrow, but at least by the beginning of next week. And yeah, I think that's. Should we? Yeah, I think we've basically finished what we wanted to say. And as if the questions are too detailed, we're not going to bore you with them. So I think we can say goodbye and thank you for your attention. We hope you enjoyed the webinar. We enjoyed giving it, at least. So even if it's not very interactive, of course, but we did enjoy it. So voila, goodbye then.
Thank you.
Thank you. Bye.